All right, so thank you everybody for coming today. Today we will be talking about dental practice transitions, and I'll be going through a slideshow and answering questions as they arise during the presentation. So I'm going to get started and jump right in because we have a lot of ground to cover. And so I'll pull up the slideshow, you'll be able to follow along with me. And then after we're done, I will drop the slideshow and we'll go ahead and talk. And so during this time, I encourage you to go ahead, unmute your microphone, or let me know if you've got a question through the chat box. As I'll be working through all of the information, feel free to just jump in there because I may not see the messages come through right away. So let's go ahead and get started. My name is Justin Morgan, and this is a dental practice transitions webinar brought to you by our firm Wood & Delgado. We are attorneys, advisors, and consultants that work with dentists throughout the United States with their business and legal needs. I'm based in California, but we've got licenses in Colorado and Texas as well. And we work with local counsel and other professionals throughout the country to make sure that our clients get really good advice that is specialized and tailored to their needs. As an initial disclaimer, the information shared during this webinar is meant for informational purposes only. It doesn't constitute legal advice. Legal advice is something that's really specific and tailored to what that particular client needs. And so I encourage you to reach out and actually retain counsel if you have a business or legal need, rather than relying on just this advice or information that you receive online or through webinars and posts. All of that stuff is really great, but a lot of times the most important nuances to what we do as advisors comes through understanding the needs of the client. Again, my name is Justin Morgan. I'll give a little professional background. I went to UCSB, graduated 2007. I went to law school at USC, that's Southern California, not Southern Carolina, and graduated 2011. I externed one summer for the Ninth Circuit in Reno, Nevada, which is where I'm from. It's my hometown. And I spent 5 years as a bankruptcy and commercial litigator. And so what that is we resolve disputes in the courts. So whether that be private dispute resolution, which is arbitration and mediation, or through the court system, which is what we call litigation. And there's a difference between litigation and trial. Litigation is the process leading up to trial. Trial is the actual thing that we see on TV. That is rarely done because it's really difficult, expensive, and sometimes it can be uncertain. After that experience in litigation, I went into corporate finance and specifically into private practice healthcare. My family's in healthcare, and so I saw this as a really great fit to get into something new. And I learned how to finance dental practice acquisition and medical loans, so startups, acquisitions, real estate at Bank of America. And I spent about 1.5 years there, and then took that experience and now use it in my transactional practice. And I act as counsel to dentists, vets, and healthcare professionals throughout the country. So I help with acquisition, sales, partnerships, business disputes on the front end, and everything in between. DSO sales as well. And then after I establish a relationship with my clients, I'll just act as outside general counsel. So I'll keep an open door policy with people as they move through their career, so that when they have questions about certain issues, they can feel comfortable reaching out. Let's see here. Okay. Now, initial considerations. And today, I'm going to be approaching this not only from the buyer's perspective, but also from the seller's perspective as well. So I'll go through and I will bifurcate how each of my advice and my approach will differ, and how your approach to the transaction should change. So as a buyer, what you should really be focusing on initially is being prepared. And so what that means is, have your initial conversation with an attorney or a CPA and start talking about your finances, start talking about what your goals are. I prefer to be the first in the door, and I'm always happy to have a conversation on the front end to help talk to my clients about where they need to be, and then make introductions to the appropriate professionals about, hey, look, these are good teams that I like working with. that are in finance, that are CPA partners, and I have contacts throughout the country, and our firm does as well. And one of the things that's also going to be important, not only is being prepared mentally for the difficulty of going through this entire process, but getting pre-qualified and having your finances in order so that you can make really good business decisions, right? And so banks call this being pre-qualified. And what they're going to look for is three big things. They're going to look for credit, cash, and they're going to look for your production. Production is, how much can you produce as a practitioner? And that they want to make sure that you are capable of taking on the amount of production in the future that you'd be responsible for if you're acquiring a practice. Credit is going to be your credit score, bankruptcies, tax liens, charge-off, all of those things. You want that to be clean, and you want it to be over 680. And then cash, you're going to want to have sufficient cash, not because you're going to need to come in with cash down. A lot of these banks will finance 100% of a practice acquisition, but you want to be able to make really good financial decisions. And having good cash is really important to do that. I think there's a heavy psychological effect of when you have sufficient runway for your business, you're able to make better decisions in terms of, this is the appropriate amount of risk for the circumstance, and I'm not shortchanging the really important things because I want to save a little bit of money. It's important when you go into business to understand the impact of cash and having a really good budget and understanding where money should be allocated and how much in order to be successful. The next piece is identifying a target. And so I've given you a small list of, let's say, sources where you can find an actual practice. But another thing that's going to be really important is analyzing who you are and what you need. If you're a person that wants to work 3 days a week and have sufficient time to raise kids or be available for family, then you might not want a large practice, right? You might want to find something that's a little bit smaller, more manageable, that you can really maximize your margin and save your time. If you're looking to build an empire or you're looking to support an entire family, you may want to start with something or start looking at practices that generate more in revenue so you have a steady stream of income, which is what we call cash flow. And cash flow is really, really important when you look at practices, because it's the one thing that's going to dictate how much cash you have at the end of the day. And that's going to enable you to do different things like investing or making other decisions in terms of reinvesting in your business or saving for the house or for rainy days, right? For sellers, it's going to be a little bit different. Preparedness is going to be, how mentally prepared are you? Are you prepared to sell? Are you willing to do it in a year? Are you willing to do it in 3 years? And also the bigger question is, how long what's your timeline as well, right? So some folks, they'll make a decision to sell and they want to sell in 3 months. And that might be great. And it might be able to happen, but sometimes it takes longer than that. And so sometimes it can take up to a year to sell a practice, depending on how it's marketed, where it's located, and how it's priced. And so those are really important things to understand. And it's good to get professionals involved at the outset, so you set expectations reasonably. And dental practice matchmaker is really good for giving sellers an avenue to reach out to potential buyers and short circuit some of the difficulties of selecting a good broker and trustworthy professionals. But at a minimum, when you start to think about selling, you're going to want to talk to financial advisor, your CPA, and an attorney, so you can make sure that your thought process is in the right place. Additionally, as a seller, you want to consider that tax returns are really, really important. Okay, and tax returns are important because the banks are going to look at those when they make a decision whether or not to lend. And so if your tax returns are very, very aggressive in terms of taking a lot of deductions and reducing your tax liability on the whole, that can be great. But what needs to be considered is that it might be more difficult for a buyer to get financing for that, because it doesn't show the cash flow that the bank will need to show to its credit departments to be able to fund that loan. Let's see. And then in terms of identifying a buyer, there are sites like a dental practice matchmaker, there's classified ads, there's networking, there's brokers, CPAs, attorneys, and there's a whole other host of alternative ways to find buyers, family and friends. Again, networking is huge in terms of finding an off-market buyer for a particular practice. One note to think about is forming a team, right? And when we talk about team, we talk about a team of professionals. They're going to help walk you through the process and that are going to have your best interests in mind. And so my position and the way that we approach this at our firm is that we want to be one of the first peoples in the door when a client decides to buy or sell, simply because we provide objective advice and we work with folks that we have good relationships with. And so we can really attest that a referral is going to be good. And we try to give out a few referrals so that our clients have the opportunity to speak with a few people and get a feel to make sure that each of these professionals is going to work for their personality types and what they need. And so when we're talking about a team, there's going to be an attorney, there's going to be a CPA, sometimes there's going to be a consultant, sometimes there's going to be a financial advisor if you're a seller. Sometimes there might be even a broker if you're a seller and you're having difficulty selling it by yourself. Now, one thing I cannot stress enough is that good legal and business advice is worth its cost, right? The errors that can be made without retaining an attorney, let's say on just a lease, can cost someone $25,000, right? And it can be gone in an instant, and that can go away with, you know, and there's other risks that can just quickly crop up that you'll never see except at the end of one's career. And on the buy side, I mean, having someone that can really identify really nuanced issues is incredibly important. And I'll give you one quick example. I had a client who bought a practice, and he had a consulting group that was working with him that, you know, basically issued a couple red flags for the practice, but didn't flag the issue of fraud. And so no one on this person's team was really digging in to the fraud analysis in terms of an acquisition. And after the practice closed, this particular client learned of fraud that was in the practice, and it was really deep. And so what happened was this practice was doing, let's say, $1 million. And then in 6 months, it was doing 220,000 because they had to re-market the entire practice and get rid of the entire staff because everybody was committing fraud and violations of the law all over the place. Now, the red flags weren't initially, they didn't pick that up, but in retrospect, and had he worked with a couple more people that with deeper knowledge, they may have said, look, like, you need to be very, very aware of fraud. And these little metrics here and here look like fraud. And this person was working with a team that held themselves as experts as well. So even sometimes even the experts can make mistakes. And in this case, it seemed like there was a junior person working on the team, and there was little oversight from someone that had a deeper experience. Now, the transaction process. I'll go through the main steps. Let's put it that way. So the first, after two parties find each other, right, is the letter of intent. The letter of intent is sometimes referred to as an LOI, and it's going to spell out key terms. So you're going to want to retain counsel before negotiating this. It seems like it's something really easy. It seems like it's, oh, hey, I'd like to buy your practice for X, and let's go ahead and close this transaction in 30 days. And then once the attorneys get involved, or there's another attorney involved, there might be some objections to some of those terms because they're unfavorable to the client and they're pushing too quickly, or they're not addressing the most important issues. And so it's important to have your advisors involved at this point, even if you think that you can do it yourself. And it also bears out in terms of a commercial lease as well. So if you jump in there without support on a commercial lease, and I've seen this quite a bit, where people will say, I've negotiated a great deal, the owner of the real estate is fantastic. They're super nice, and they're super nice because they're getting a deal, right? They're kind of laughing at you. And once you have that locked in place, it's very hard to retrade on terms without walking away from the deal. And it's the difference between negotiating 8 months of rent abatement on a 10-year lease and negotiating 2 months. And that person that negotiated 2 months thought they were getting an awesome deal, and they didn't want to pay for counsel to work through it because they thought it was a simple situation. But in reality, they probably bound themselves in a really difficult way. And also, when you're selecting a professional, you may want to talk to one or two, because styles they differ widely, right? Some people are really conciliatory, some people are kind of relaxed, some people are kind of pragmatic in their approach. And so you'll want to have someone that's going to match your sense of things. Okay. Once you have the letter of intent, the parties will sign it or they won't sign it. There'll be diligence. And so there's going to be diligence that's conducted on the equipment, the premises, the financials, patient records, and anything else that's going to crop up, right? So you really want to dig into the practice. And the larger the practice, the more diligence is necessary, but also don't disregard the importance of diligence on a small practice. Because if you've got a $50,000 asset sale and you're walking into a practice and you don't really diligence the equipment or the financials, the equipment or the premises simply because you think it's something cheap, you can do it relatively quickly and it'll be painless. There can be liabilities and there can be things that are overlooked that it can cost you $25,000 after the fact. So you really want to be careful about that. The next step is the purchase and sale agreement, which is going to be drafted by it should be drafted by the attorneys, right? We want to make sure that you have attorney drafted documents, because when other people do them, they may think they understand what's going on, but they don't really understand the nuances of law and why certain statements have been put into those documents. Each of these documents and a lot of the deals, even though they feel like they are the same, they're actually very customized, and they're going to be as unique as the sellers and the buyers to them, right? And so you want to make sure that everybody's on the same page, because once money has changed hands, it's really difficult to unwind. It's really difficult, if not impossible, to unwind the transaction. And so I would expect it to take several weeks for a purchase and sale agreement to get negotiated. And that's going to be, the initial document will be drafted. It'll be reviewed by the other side. They will turn the document, so they'll make their changes to it and send it to opposing counsel. And then it'll go back and forth until each party kind of gets closer and closer to agreement. And finally, there's going to be a lease agreement. And these are the basics, right? There are all sorts of other documents and agreements that can occur during a transaction, but the ones that the steps that you see here are the basics, right? And so the next piece is going to be the lease. And so you're going to have a commercial lease for the actual premises on which or in which the practice is conducted. And so you're either going to be negotiating an assignment of the lease or a new lease, and then you're also going to be speaking and planning about what happens long term, right? So if you get a lease that's got 2 years left on it, and you've got a 5-year option to extend it, but that 5-year option has pretty arduous terms, you'd be best advised to understand those nuances and how to better approach that. And that's something that the attorneys will handle. And sometimes we'll get brokers involved to help address the financial terms, as brokers on the real estate side have local knowledge of the market that's super helpful. And then when we talk about closing is going to be the exchange of funds and the bill of sale. So the bill of sale is like a receipt, and the exchange of funds is obviously the purchase price. And then the parties will reallocate prorations and other expenses amongst themselves to make sure that everything is closed and to reduce the amount of friction after the transaction. It can be really frustrating as a buyer and a seller to have issues arise, like the collection of accounts receivable, if there's work that hasn't yet been completed, or if there are cases for retreatment that need to be completed. The parties need to know how to address that in a clear way that's going to avoid difficulties arising between them. Okay, and so like to talk about some red flags, right? And so if this applies to you, please do not take offense, but consider that it is going to be something that can potentially harm your ability to move forward with the transaction. So for sellers, you want to take a look out for the buyer's personality and make sure that there's some level of meshing, right? Because and there's not red flags in terms of, wait, this is someone that wants to do something completely different from my practice, even though they've put in an offer. Because you don't want to get all the way down the line with someone who wants to do a cosmetic dentistry practice when you've got a bread and butter practice, because you don't want them to back out at the last minute. Uncertainty, if their approach is less than firm and less than devoted and focused, there may be some current concerns there that they may be just kicking tires, right? And so when you jump on the phone or you see someone in person, the way that they speak, the level of knowledge, or the way that they're focused on that transaction is really important. And that also works to their level of preparedness as well. So if they show up to the practice to have an interview with the seller and they don't know anything about it, they haven't looked at anything, they don't have an attorney yet, they're really not ready to go, or they haven't had those conversations. It's important to have those conversations about who the prospective buyer is with your team, so that if you're entertaining multiple offers, that you can make the best one, you can make the best choice with the one that has the highest likelihood of closure. Other things are going to be financing delays, and then unnecessary delays or lack of communication. Financing delays arise from, they can arise from two places, right? They can arise from the buyer's financials, or they can arise from the seller and the practice itself. And so sometimes there's going to be questions about the financial records of the practice and what certain things mean in terms of on the profit and loss statement. And sometimes it's going to be based on the buyer. Sometimes they can't get financing lined up. They've got unique issues of credit. They've got unique issues associated with the cash, where they can't get a guarantor to sign on or get a guarantor approved for an actual practice. And so it's going to be very nuanced as a seller. And so you should have counsel that is able to read a balance sheet or a financial statement and say, hey, look, you've got a really big, strong practice, but because of margins, it might be difficult for someone that's 3 years out of school to be able to close on that. You might want to look for someone that's had 10 years of experience or 8 years of experience with zero debt, that sort of thing. Now, in terms of red flags for buyers, personality of the seller is going to be important as well. Are they disorganized or are they organized? If you walk in and it's paper charts everywhere and they're disorganized, you can kind of glean that that's going to be in your future. There's going to be a lot of work to get that up to date and in a place where it's going to be beneficial for you. Also, slow dissemination of information that reflects sometimes a disorganization on the counterparty. If they don't have their financials prepared on a monthly or quarterly basis and they can't really readily give that to you, then that might be a problem. You don't know if it is, but it might be a problem. Additionally, look at the way they keep the records. Do they have bad reviews online, if they have an online presence? And then also accusations, lawsuits, accusations against their license or lawsuits. And sometimes, in bigger transactions, it warrants a background check. You want to know if they've declared bankruptcy 6 times. You want to know if there's 8 lawsuits against them in 4 counties. So those are all things that we go through as attorneys with our clients to talk about throughout the process to make sure that they're making good decisions. I'd like to open this up for questions. My contact information is justin@dentalattorneys.com, and my phone number is 213-369-8698. So at this point, I'm going to take this screen share off, and I will field whatever questions you have. Here we go. I've got 3 in the chat.
Yeah, Justin, thank you very much. Excellent points. For all the people here, either looking to sell or buy, if you haven't done it before, there is a whole lot to it. So, having someone that's walked the path and that can guide and let you know what's going on is a tremendous benefit. Bridget and I are sitting here just listening to this, and we remember the 2 or 3 false starts before we actually were able to make it happen.
Thank you. So I've got a question from Janice Coe. How many periods of time of production would the bank want to see? For example, I used to have high production. I changed my job and my production is not as high. Would this work against me in the future? Now, I spent some time as a banker, and what you should do and what the banker should do is they should request some, like a quarter or 6 months of your production records at your prior job, so that you can show, hey, at a good, strong cosmetic dentistry practice or a strong practice, I can make $4,000 a day working 4 days a week. If you get production records, for a year, you might as well grab those. And good banking and lending groups will know those differences, and you can ask for that. So that's best practice is, as you move from associateship to associateship, get access to your production reports and make sure that you keep those in your files, so that when you go to buy a practice, you have those at the ready, and you can say, oh, well, my production is $4,000 a day when I have a full schedule at a good practice that's busy. And I'm looking at a practice that does $750,000 of production. Therefore, I can handle it because there's some hygiene in there that is going to be taken care of by someone else.
Well, and to flip that around, if she's asking from the buyer side, yeah, you definitely need to show that. Some of the problems will come from the seller side, where they will kind of get on the high ground. They'll coast for a little bit. They'll just start to slow it down. And then they realize, well, this is $1 million practice. I only did 600,000 because I was tired, I was bored. And so they want that kind of valuation. So the sellers need to think about this as well, when they're going to do it and how they want to get their value, because the banks do say, what'd you do last year? What'd you do the last 2 years? They won't basically say you've got the capacity to do more. It's what did you actually do?
Yeah. Now the next will be a question from, jump on here real quick, actually. This, wait. Let's see here, oops. The next question is from Bridget Jorgensen, and it is, do you have to follow through with an agreement if the lease is terrible or diligence shows stuff you did not expect? I think she's got two questions. This is, so in the purchase and sale agreement, we draft contingencies, okay? And so contingency means that the transaction does not need to be completed until the contingency is satisfied or waived. And so there's ways, and there's basically out clauses that will allow a buyer to exit a situation if the lease isn't good. And what I mean by the lease not being good is the landlord will not assign an option, or they won't agree to some really fundamental terms that are critical for a buyer to be protected. And then additionally, you can also, and her second question seems to be, a banker can also slow things down, which is basically a financing contingency, which is important to understand, that you want to have your financing lined up, and you want to be able to get out of that in the event that the financing contingency does not come through.
The other thing we'd say is that if you've got a deal going and you're trying to work these things and the bankers are slowing up for whatever reason, sometimes it's not a problem with the practice or with the buyer, that some of these financial institutions, for whatever reason, especially the very big ones, can torpedo a deal or cause a deal to be drawn out. So people should always know that just because they're talking to one banker doesn't mean that they're locked to that banker until closing happens. And if for whatever reason a deal is kind of being sent sideways, they need to make sure that it is not something wrong with the deal, and that it could just be a particular banker isn't closing things out, or they're having access, or their portfolio is out of balance or something like that. So it's quite possible another local banker, we had great success with the local bankers instead of the big bankers, even though the big bankers are the one doing all the advertising.
Yeah. And it really depends on the team that you're working with, and also the complexity of the deal. And so sometimes there's quicker teams within banks, and there's more solid teams within banks. And sometimes the local bank is a good option. It really depends on the deal itself. And so there's, if if that's it on that point, did you have anything else to add?
Nope, that's it.
My
Okay.
first question was, if you do the letter of intent and you say, yes, I want to buy this practice for this amount of money, and then you find out, something like the lease is a lot higher than you anticipated, or they are doing some weird things, in the office you don't realize until you're actually there. Do you have to follow through on that letter of intent, or can you say, you know what, this is not what I anticipated, and I'm just going to have to back away?
Yeah, it really depends on the LOI, right? And so a letter of intent is not binding, right?
Okay.
By definition, a letter of intent is, this is the intention of the parties, and we're going to set some ground rules. Now, there are going to be binding clauses in an LOI. For example, confidentiality, the deposit, and how we're going to deal with the deposit. The LOI might set forth certain timelines for contingencies. And so the way that I structure my letters of intent is that I'm going to have 30 to 45 to 60 days for diligence. I want to have that for the lease and all of those other matters. And if things start to turn out wrong, then I want my client to be able to back out and get their deposit right away. And so you've got, go ahead.
I have talked to a couple of people that have went through the letter of intent phase, and then the doctor actually decided that they got a better offer from a DSO. And even though they had signed a letter of intent and they thought they were going forward, all of a sudden they're like, nope, not going to sell to you. I'm going to sell to this DSO. And then they're like, okay, I've been, juggling all this stuff for 60 days and now you won't even sell it to me.
Yeah. And so when I do deals in, let's say, the Northeast, and I know that I've got DSO competition, I will make sure that there's an exclusivity provision in the LOI that the seller cannot negotiate, it cannot list its practice, or entertain other offers until the 60-day term is up. And so there's ways to address competition, and that's really important when you have, let's say, a very hot practice or a practice that's going to be very competitive. So you can have letters of intent that address those issues, and it's going to be specific to the practice and that deal.
Okay.
And then I've got a question from DP, and it's, where do you find brokers to support buyers? I know that there were brokers on the buy side. I don't know a ton of them that I refer in, simply because a lot of those efforts can be addressed by speaking with your CPA and your financial advisor or attorney. But it depends. I mean, there's some teams out there that do a good job and can walk you through those initial processes of, let's talk about the target, let's talk about the financials, the production, whether it meets your needs. I end up going through that kind of list of questions and working through those questions with my clients over time. And so we structure, the legal fee as somewhat of a consultant fee, and also wrapping in the cost to actually do the deal as well. And so if you want to reach out and we can talk about that particular issue in more detail, and I can give you a deeper opinion on that. Okay.
How would the buyer's broker be paid?
So sometimes buyers brokers will ask for $7,500 or $10,000.
Wow.
I don't want to express an opinion because I haven't worked with a ton of buyers brokers. And so I'd like to leave it at that.
What about sellers brokers? What's your opinion there?
Yeah, well, look, sellers brokers can make they can make more money for their client than their client could on their own, right? So when we're talking about, let's say, a private sale, a private sale in, maybe not as competitive of an area, or where there's fewer buyers, it might be be difficult for a broker to make that person more money, but they may be able to bring that buyer in because of their contact in the community and knowing people. But in other areas, what their function is they are essentially a facilitator, and they can bring in buyers, vet those buyers, and they do it for a fee, and that fee can sometimes be justified, and often is justified by the price that they're going to get for the practice. Now it's highly dependent, right?
Doesn't the practice have to be evaluated, and wouldn't it be that same price if the accountant is ethical?
So I would say to that look, if you've got 3 offers on a practice, and they're all at full price, that's better than 1 offer at full price.
Sure.
And so there's some value there. It's squishy, right? Like, you can't say 100% of the time brokers are bad or brokers are good, but oftentimes when I'm doing deals, when there's a financial professional involved, you're going to command a higher price, and it's also going to depend on the broker, right? Like, I've seen a practice that's been valued at $500,000 because the broker wanted to get it off the books very quickly, and the value of that practice was more close to $925,000. So if the buyer or the seller went with that initial valuation by that broker, let that lapse, and then sold it for that much, he would have left quite a bit on the table, and that was just speaking to the quality of that particular broker. With respect to real estate and some practice sales, it's important. Now, if you're looking at a sale to a DSO, or you're looking at, partnering with someone else that's sophisticated, they may come back with really, really detailed analysis supporting their practice sale price or purchase price. And you're going to want someone that's sophisticated and savvy to be able to push back on that and essentially say, hey, look, you've stated that there are all of these add backs that don't qualify. And, you're right about 3 of them, but you also failed to normalize X, Y, and Z, which we told you about. And that actually bumps the price up by 50,000 or 100,000. So having someone financially savvy to counterbalance someone else that's financially savvy is really important. And that's why you need a broker when you do a commercial lease. And that's the example of someone saying, I negotiated 2 months on a commercial lease of rent abatement, when the market rate in that area at that point in time might have been 6 or 8 months. And they negotiated, like, for example, a rent commencement date that was 3 months in advance when they're doing like a startup, when the actual rent commencement date that's negotiated by brokers could be 7 months. So it's not a science, but often there are professionals that do and are worth what they charge. And sometimes it's difficult to know that up front. And that's why it's important to network and get a good sense of, not only does this person have good marketing, but do they have a good reputation of supporting their clients and making sure that they're in a good space.
Makes sense.
All about building the team.
Yeah. So it does not seem that I have any other questions. And I allocated 45 minutes to this. So if no one has any other questions, please understand that this is being recorded, and I'll have a team that kind of reformats it. So it'll either be in sound bites or it'll be reproduced for later consumption. So you can hear it again and again. I'm going to drop my email and my phone number into the comment box. It's justin@dentalattorneys.com. And then my cell phone is 213-369-8698. And so you can text me or email me. Email is the best way to get a hold of me because I check it constantly. And my phone number is also helpful as well, just so you have it when you want to set up a meeting and you know who's calling you back. But I do appreciate everybody's time, and I want you to all have great days, and I'll be around.
Okay. Thank you very much.
Another good session. We look forward to next week.
2 weeks.
Thank
2 weeks.
you. All righty.
Bye.